if I were in a regular person's shoes wanting to know, hey, what do I need to be aware of? That's really what could be at play here.
We're the Armed Attorneys. Today, we are answering your most frequently asked questions about the ATF's brand new pistol brace rule that you have posed in our comments section. I think I'll give a warning, I guess, right here at the beginning, which is that there are a couple of these questions that are brand new, novel issues of law, never been interpreted by a court before. If you're wondering why all of the lawyers and all of the YouTube people have different answers to a lot of these things, that's why. But the benefit you have with Armed Attorneys is we have sat down with our law firm full of attorneys who only do two-way work, and we've come up with what we think are the best answers to these questions with the information we have right now. So if you're interested in a bunch of attorney opinions, stick around, and before we get started, show your support for the Second Amendment by hitting the like button.
Today's episode is sponsored by We the People holsters. We the People holsters have become the must-have Kydex holster for inside the waistband concealed carry. They make custom molds in-house with features that can make adjustable cant, ride, and tension.
They offer a holster that fits every concealed carry position. All We the People holsters come with a lifetime guarantee and are 100% made in the USA. They offer custom printed designs, making your holster a unique experience like none other.
So with incredible customization, find the perfect holster for your everyday carry. Check them out at wethepeopleholsters.com, and thank you for making this content possible. Today, we're going to be answering the questions, like Emily said, in our comment section. Is removing the brace enough? Does that make you comply with the law? Can they use the Form 1 against me? Is it a trap? We've seen that discussed online. Can I switch out the brace with a traditional stock after it's, been approved? And do I have to destroy an imported pistol now that they're considering it a rifle under 18 USC 922R? So these questions kept coming up over and over and over. So to start things off, let's talk about that first question. Is removing the brace enough?
Yes, it is enough. There are so many people who are like, you have to destroy that brace. No, you don't. You cannot have constructive possession, and the pistol that you are left with cannot still qualify as an SBR, right? Based on whatever, is on the back end of it, right? Does it still provide enough surface area such that you can shoot and meet the ATF's other qualifications? But assuming that answer is no, yes, removing the brace is enough. You do not have to permanently alter the brace. I wouldn't, because I don't know how this is all going to play out.
Right.
So just don't have constructive possession. Don't store them right next to each other in the same safe. Have two different storage facilities, right? Do you have anything to add to that?
Yeah, I would just say I want to differentiate this from the way machine guns were treated when they had machine gun amnesty. Having a integral machine gun part was considered a machine gun in and of itself. And so we saw that with bump stocks, for example, machine gun part. They claimed the bump stock was a machine gun part.
The bump stock was the machine gun.
The bump stock was the machine gun. And this rule, it's different. We don't say that here. Now, this is like anything in law. It's about a risk tolerance calculation. Keeping a quick remove, arm brace in a case with you at the range out in public, that's pretty risky.
Pretty risky.
Risky behavior. Less risky, taking it off and storing them together. Even less risky than that, taking them off, storing them separately. Even less risky than that, taking it off and destroying it if you think that's in your best interest.
Storing it off-site. There's all sorts of, depending on how much risk tolerance you have. But there is nothing that says you must destroy it.
No, absolutely not. The next question that we got from folks is, can they use this Form 1 against me? Is it a trap? We saw, quite a bit of hubbub online, discussion in forums about, hey, if I get denied my, Form 1 application, have I still served this stuff on a silver platter? Is this a trap to basically turn people into felons overnight? What is this 88-day thing that relates to 4473s? Don't worry about that stuff. And even we're concerned about it. I fell back on my defense attorney stuff. I don't like talking to law enforcement, but I think there's a little bit more to this because, we have a specific provision out of the tax code that says what?
Yes. So we've got 26 USC 5848. And I'm just paraphrasing here, but hopefully we can throw it up on screen, producer. Essentially we've got when you are required to submit documentation to the government for registration, et cetera, the government cannot use that document directly or indirectly as evidence in a proceeding against you. Now, there's an exception for providing false information. So, if you're providing false information on your Form 1, that goes out the window.
Right.
But I think a lot of people sort of threw their hands up and were like, aha, you can't use it against me. But, any lawyers out there watching read that very carefully. In a proceeding against you as evidence, this particular form, we're not talking about the information itself. So, Richard, how does the government still use that Form 1 against you?
Yeah, we have a couple of things at play here, but the biggest one is independent source doctrine, which essentially means, if the government can prove up a law violation through an independent source, that would cure any, let's say, protection you might have under the law. Sometimes we think of an illegal search. I mean, we learned about these cases in law school. I mean, this isn't rocket science stuff, but, the feds, they do this. They'll break into someone's house, conduct an illegal search, confirm criminal activity. None of that stuff would be admissible in a court, but then they will go and perform a legitimate investigation to confirm that information, and that material comes into court. So if they could discover this material independently,
source, inevitable discovery. Now, just to be clear, we don't think the ATF is going to break into your house because you committed a Form 1.
That's just an example.
That's an example.
Yeah.
But it's the issue at hand remains the same, which is you've submitted a Form 1. Let's say they find that you're a prohibited person. Can they use that Form 1, let's say, just prosecute you right away and use that Form 1 as evidence? No. There is a provision in the United States Code that says they cannot do that unless they find that you knowingly provided the false information. You fall into that exception. But can they, well, I guess we have a middle ground, which is can they use the Form 1 as the sole basis for a search warrant?
Probably not. No, I don't think so either.
Can they use that Form 1 and say, aha, I'm going to investigate Richard now through all of the means available to me as the federal government?
Yep.
Separately and independently, and never ever use this Form 1 in the inevitable prosecution against him? Sure.
Yeah, 100%. Can they come and knock on your door and say, hey, do you have a firearm? Start chatting you up. Go visit your local range. Hey, does so-and-so shoot here? Go talk to your local police department.
Start scouring your social media. I mean, there are a million ways to initiate an investigation based on this Form 1 that do not violate that provision. Now, do I think with all of the uptick in Form 1s that they're really, really going to do? Do I think that the probability is likely? And Richard and I might disagree. I don't think it's super likely, but is it possible even given this provision of United States Code? Absolutely.
Yeah, and maybe I'm going to put on long-term prediction hat. If we see a crime committed with one of these, with one of these SBRs, 10 years down the line, and Congress goes and funds and they go back and they start opening up all these forms again, maybe we see something like that. They've done that with background checks in the past. I'm putting on a long-term speculation hat.
Long game.
Yeah, long game hat. But
I just see my fallback is the government is incompetent. So,
but I'll borrow a phrase from you. Is it a trap? Trap is relative here. We're communicating with the federal government regarding possible criminal offenses. I don't like that kind of stuff. But that's the information that if I were in a regular person's shoes wanting to know, hey, what do I need to be aware of? That's really what could be at play here. So that's the risk. Now, the next question that comes up is, could I switch the brace out with a traditional stock after approval? And what are you talking to folks about?
Well, the ATF actually put out an FAQ on this and said, sure, SBR is an SBR. You sure as heck can. Normally, when we have an NFA item and we want to modify that item in some significant way, you send a letter to the ATF, you let them know what you want to do, and the ATF will send you a letter back, hopefully saying, yes, go ahead and do it. And then you can do it. So if you want to change the caliber or you want to swap out the barrels, you've got, ATF permission, you go for it. So the question became, do I need ATF permission to go from arm brace to traditional stock? And according to the ATF FAQ, the answer is no, unless it changes the length of the SBR.
Yeah, unless it changes the description of the item, which that makes sense to me.
Makes sense.
So if you find a stock that matches the identical length of the brace, then theoretically you wouldn't have to, notify the ATF, obtain approval. If it's going to change the overall length, which I imagine that it would, I mean, some people are going to fall into this category. If it's going to change the overall length, at that point, that's when you would need to get pre-authorization from the ATF. Now, the question is there something else that we saw I just wanted to address very quickly? Is there going to be kind of two classes of SBR? No, there's going to be one class of SBR, just like Emily said. That's what you need to worry about with that. But the last question, and this one has a little bit more to it. Yeah, this is a little bit more to it, is do I have to destroy an imported pistol, now considered a rifle, because of 18 USC 922R? Now, this is our general prohibition on assembling a foreign, basically what would otherwise be a foreign imported rifle. And there's a little bit to this.
Yes, there is a lot to this. So let's start with this actual provision of the United States Code. So we've got 18 USC 922R. It shall be unlawful for any person to assemble from imported parts any semi-automatic rifle or any shotgun which is identical to any rifle or shotgun prohibited from importation under Section 925D3 of this chapter as not being particularly suitable or readily adaptable to sporting purposes, except that this subsection shall not apply to, and this is basically your government exceptions, right? 1, the assembly of any such rifle or shotgun for sale or distribution by a licensed manufacturer to the United States, or any department or agency thereof, or to any state or department, agency, or political subdivision thereof, right? So we can sell them to law enforcement. The assembly of any such rifle or shotgun for the purposes of testing or experimentation authorized by the Attorney General. So those are not exceptions for you and I.
No,
right?
no.
Now, that's 922R. So then, of course, the question becomes, right, if I have, well, I guess let's start, we have several questions. Let's start with the cases, maybe.
Yeah, because I think part of, as being a criminal defense attorney is advising people, it's all about risk. The risk of prosecution under this section, the case law comes up, I would say, pretty shallow in this area.
It does. And I'll tell you, that is the case with most gun laws over and over and over again. I mean, when I Google when I Westlaw Google
Sure.
922R, when I put it through the search engine, I don't expect much to come up. And sure enough, very little comes up. So we have 2 relevant cases involving 922R. 2. The first one, we've got a guy who had an FFL in the early 90s. He got it yanked for a variety of violations. Then in 1999, he reapplies and says, I want to get my FFL again. And he gets denied because they're like,
Right.
no way, man.
You're assembling rifles.
Yeah, well, not just that. I mean, there's all sorts of stuff that he was violating.
Right.
So he appeals that decision. It goes to the Northern District of Indiana. The district court looks at it and actually affirms the decision and says, you don't get to be an FFL again. But what did he do? Well, one of his violations was a 922R violation. He was importing SKS rifles, and they have a bayonet lug, and he was actually attaching bayonets to them.
Right.
That was a 922R violation. When they yanked his license, they found that it was a 922R violation. But number 1, he didn't get prosecuted for it, right?
No, this was just him appealing a denial for an FFL.
Yeah. And number 2, the end users he was selling them to didn't get prosecuted, right? From everything we can see. So that's just things to keep in mind. Let's go on to the next case.
Yeah, the next case, we have an individual who essentially, he petitioned the court. He wanted pre-authorization, essentially saying, hey, I would like to start assembling these rifles, and this is a violation of the Second Amendment because, this 922R provision, this was out of the Eastern District in Louisiana, if I remember correctly. And the court there said, this is the Fifth Circuit. This is also pre-New York State Rifle and Pistol Association v. Bruin. They said that this did not violate the Second Amendment. Right.
So he actually didn't violate 922R, but he wanted a declaratory judgment that said he could, that said, I can engage this behavior. The court said, no way. But that's all we've got on 922R. So first of all, I'll say that any lawyer who tells you that they know definitively what's going to happen with 922R is full of it, because we have very little information. All we can do is look at the statute and interpret based on our experience and opine on what the arguments are going to be and what the court's going to do and what the ATF's going to do, right?
It's a little silly to me because I see a lot of different discussions going on. I mean, this is why we have courts adjudicating disputes of law, in fact, because, 2 people are reading the same thing, come up to different conclusions. If the law was so black and white, we wouldn't have courts. But,
correct.
So, I mean, this stuff is, we do have a first of its kind rule, first of its kind enforcement, statutes that maybe we don't know how they're going to interact with these rules. And so, I would just, everybody take a big old deep breath. Big old deep breath going forward. But the crime here, I think we need to focus on, the crime is assembly.
That's the crime. Go back. Look, flash that law up on the screen again. Look at the crime. It's not sale. It's not ownership. It's not possession.
Yeah.
It is assembly. So, scenario 1, you did not assemble that SBR. It came braced. Richard, did you, and this is again our opinions based on no legal interpretation of this yet, except for our own, just opining on it. If you did not put that brace on it, did you commit the crime of assembly?
No, clearly not.
And I think we have something to back us up in that I can find 0 prosecutions of whoever that first guy was selling those SKS rifles to.
Yeah, I mean, it's shallow. That's all I can say. I mean, there's nothing.
There's
you
nothing
hear
there.
about all these different, technical violations and things like that, and then when you don't see people getting prosecuted for it, I mean, maybe we have a law in the books, but it's not getting enforced. Does that make me as worried? I mean, it kind of reduces my worry level a little bit.
It reduces my worry too. Also, remember, they can't just haul you into court and prove something outside of what the statutory violation is.
Right.
They can't haul you into court, prove up possession, and convict you. They have to prove up assembly.
Okay, let's do the scenario where you assembled it. Maybe you purchased this pistol, you put the brace on it. What do you think the government thinks about that?
Well,
and again, this is just kind of our speculation.
Yeah.
But
I mean, you committed the crime,
Right.
right? You took the pistol that's got all the foreign-made parts, and we didn't go through the actual, they're not sub-laws, but the laws referenced in 922R that tell you how many parts and, goes through in detail. But let's say it qualifies. You took the foreign-made pistol, you made it into a rifle by your own assembly, and you violated this law. You crimed, right?
Yep.
You did it. However, and unless you have really, really advertised yourself engaging in the assembly of, how are they going to prove it? Take the brace off.
Right.
Take the brace. It's like if police come to me and say, I have on good authority that you were doing cocaine last month. I wasn't, but and I'm like, where's the cocaine, guys? Because I did it. It's gone.
Sure.
What are they going to do? What are they going to charge me with, Richard?
Yeah.
What are they going to do?
It's going to be a uphill battle for them to prove. We'll say that much.
It's in my nose holes. You can't charge me with that. And so same principle applies. You perhaps did the assembly, but if there's no evidence of your assembly out there, and then you engage in the disassembly such that you just have a foreign-made pistol, and in that case, I'd probably recommend destruction or getting rid of the arm brace, just in case there is some evidence out there that you did assemble, you don't know, or, store it off-site, whatever you want to do. But how are they going to prove assembly? How are they going to do it?
Yeah, I mean, absent some really extraordinary facts like, they know this gun is shipped with the brace detached. They surveil you picking it up from the FFL, taking it home, and then hitting, knocking on your door and discovering it assembled, 5 minutes after it came into your possession.
Yeah.
I mean, absent some really extraordinary circumstances, I can't see it. Or maybe you taking a video of yourself and posting it on social media.
And the ATF really mucked all this up because they addressed the comment in the rule, and they're like, well, you're worried about this, but don't worry because it's not curable. Basically, like if you've put your brace on your foreign-made pistol, you basically, you can't do anything. You've done the crime and you can't fix it.
Yeah.
Again, ridiculous. It does not mean, in my book, in the law by Emily Taylor, it does not mean you have to go surrender these incurable 922R violations. Don't show yourself making the assembly. The crime is assembly.
Right. And I think, good reminder, don't talk to law enforcement. Don't corroborate this stuff. Don't photograph yourself. Don't post these things on social media. Because again, while there may be a law on the book, I mean, just because you did the crime doesn't mean you're guilty. And the way that you prove doesn't mean that they can prove it. How about that?
Technically true.
Yeah. So that goes to all of these things. Now, not telling people to break the law. Don't want anybody breaking the law.
No, we can't advise you to break the law.
No. And if you have a foreign pistol, the ATF has put you on notice. They're going to consider putting a brace on these things, a violation of 922R. So obviously don't do that. Now, those are the most common questions we gotten. But if you're thinking, hey, I just need the basics here. I feel like I missed something. We have the entire rule broken down in plain English right here. You got to check it out. And until next time, we're the Armed Attorneys.